Hey y'all, what's up? Welcome back to my channel. So today we're going to get into what exactly is a billing error dispute. We're going to break it down and then we're going to show you how you're able to go ahead and execute a billing error dispute. As you all know, before you're able to actually get any type of remedy, there's a lot of studying that has to happen on the back end. So again, like I said, today we're going to go ahead and break down what a billing error dispute is because I know you all may have been seeing it across the internet. So let's go ahead and let's get into it. Now, this is the definition of a billing error. And with a billing error, you are going to be bringing this billing error dispute under TILA. The law is 12 CFR 1026.13, and this is going to be the billing error resolution dispute law. This is what you're going to be using to pull out all of the necessary laws applicable to you and then executing your dispute using this one law and this one law only. So we're going to go ahead and get into it. Now, with a billing error dispute, what you're doing essentially is you're going to go ahead and show the creditors how they misuse your credit card information, right? And you're also going to let them know that you know exactly what your credit card is. And that's pursuant to 15 USC 1602L, right? So in order for you to go ahead and resolve your billing error dispute, you're going to be notifying your creditors of the error using this Regulation Z law of the Truth in Lending Act, which is also known again as the billing error dispute, and referring to 1026.13, the billing error resolution law. So what is billing error resolution defined? So by law, the definition of billing error for the purposes of this section, and this would be the section they're referring to, the term billing error means a reflection on or with a periodic statement of an extension of credit that is not made to the consumer or to a person who has actual, implied, or apparent authority to use the consumer's credit card or open-end credit plan. And I just explained to you all your credit card would be as you define a credit card pursuant to 15 USC 1602L, right? So you're essentially going to be calling into question a billing error. The law doesn't state that a billing error is the law doesn't state here. The law doesn't state here that a billing error is a billing question. So that's essentially what you're calling into play, a billing question. You are going to be questioning who has actual, implied, or apparent authority to use the consumer or your consumer credit plan or open-end credit plan. So that's the whole idea behind a billing error resolution dispute. Now, you do have requirements under law to go ahead and provide the creditor with a notice. So you do by law have to provide your billing error notice to them. And this is the requirement per 12 CFR 1026.13B. So a billing error notice is a written notice from a consumer. So you have to do that. That's your requirement. You have to provide the billing error notice to the creditor, right? So it's from a written notice from a consumer that is received by a creditor at the address disclosed under 1026.7A9 or B9 as applicable, no later than 60 days after that creditor has transmitted the first periodic statement that reflects the alleged billing error. So they're letting you know here that you have a requirement to go ahead and provide them with a notice notifying them that there is an error no later than 60 days after you get your first statement, right? Your other requirement is that you enable the creditor to identify who you are, your name as a consumer, and your account number. So that has to be included in your notice. They need to know who you are and what account that you're referring to. And so this is also a requirement. And is a requirement. And to the extent possible, indicates the consumer's belief and the reason for the belief that a billing error exists. And as I just explained to you, the reason that you're going to call into question that a billing error exists or that you have the a reason to believe that the billing error exists is that you want to call into question their actual authority to use your credit card, which is pursuant to 15 USC 1602L, your credit card is your social security number. You're calling that into question. You're also going to include in that written notice the type, date, and amount of that error. Now, when it comes to resolution, there is a time limit that they have to go ahead and provide you with a response. So 12 CFR 1026.13C gives them a time for resolution. So the general procedures are that the creditor, being whomever you are calling into question the billing error dispute, that creditor shall mail or deliver you written acknowledgement to you, the consumer, within 30 days of receiving that billing error notice, unless the creditor has complied with the appropriate resolution procedures of paragraphs E and F of this section. And again, that section is the 1026.13 billing error resolution law. That's the section they're referring to. As applicable within a 30-day period, and 2, the creditor shall comply with the appropriate resolution procedures of paragraphs E and F of this section as applicable within 2 complete billing cycles, but in no event later than 90 days after receiving that billing error notice. So their time for resolution, they're telling you that they have up to 90 days to go ahead and respond to that billing error notice. So they have their requirement to resolve it or to respond to you within 90 days. So these are very pertinent. If these are not done, then you do have a claim to move forward and get remedy, right? So the rules pending resolution. So this is very pertinent with the law. So until a billing error is resolved under paragraph E or F of this section, the following rules apply. So consumers have the right to withhold disputed amount. Collection action is prohibited. The consumer need not pay, and the creditor may not try to collect. I know you all have been seeing me post that across my social media accounts, that you can put your account in that do not pay, do not collect status. This is the law that allows you to do so. It tells you right here in the law that consumers, until this billing error is resolved, consumers have the right to withhold that disputed amount, whatever it is. Collection is prohibited. The consumer need not pay, and the creditor may not try to collect any portion of any required payment that the consumer believes is related to the disputed amount. That's including any related finance or other charges. Now, if the card holder has enrolled in an automatic payment plan offered by the card issuer and has agreed to pay the credit card indebtedness by periodic deductions from the cardholder's deposit account, the card issuer shall not deduct any part of that disputed amount or any related finance charges or other charges if that billing error notice is received anytime up to 3 business days before the scheduled payment date. So this is just letting them know, if you are on automatic payments or deductions, that if they receive your notice 3 days prior, that they can't go ahead and deduct that payment. They're not supposed to deduct that payment. That's what that is telling you. And number 2 is also letting you know that adverse credit reports are prohibited. So the creditor or its agent shall not directly or indirectly make or threaten to make an adverse report on your credit report to any person about the consumer's credit standing, or report that an amount or account is delinquent. So they can't report when you don't pay and it's in that status. They're not supposed to go ahead and report that amount or that the account is delinquent, because the consumer failed to pay the disputed amount or related or other charges. So it's letting you know they can't report you to the credit bureaus because you're refusing to pay, or that you failed to pay, not refusing, but you failed to pay, because that's the law. It says that you're not required to pay, right? Continuing with the pending resolution, right? So acceleration of debt and restriction of account prohibited. So some creditors are notorious for limiting your account, restricting your account, and closing your accounts if you call into question a billing error. One of those being discovered. So this law is referring you and letting you know that that is against the law. So creditors shall not accelerate any part of the consumer's indebtedness, or restrict or close a consumer's account solely because that consumer has exercised in good faith their rights provided by this section. So if they do that, then that creditor may be subject to the forfeiture penalty under 15 USC 1666E. So the law is telling you if they restrict close your account off dribble off rip, you have a claim, and that that they are forfeiture or subject to forfeiture penalty under this law. So your remedy is there if they go ahead and fail to comply with this subchapter of the law. And again, it's going to be for failure to comply with the requirements of this section. So it's letting you know that right there in the law, right? And then another thing that they're prohibited from doing, they're permitted creditor action. So a creditor is not prohibited from taking action to collect any undisputed portion of the item or bill. So it's letting you know that they can still try to collect it, but the law is telling them that you do have the right to withhold it until they go ahead and resolve it. So they are not prohibited from taking any action to collect any undisputed portion of the item or bill, from deducting any disputed amount in related finance or other charges from the consumer's credit limit or the account, or from reflecting a disputed amount in related finance charge or other charges on a periodic statement, provided that the creditor indicates on or with the periodic statement that the payment of any disputed amount in the related finance or other charges is not required pending the creditor's compliance with this section. So they have to be in compliance with this section. Now, when it comes to execution, there are two ways that you are able to execute the billing error dispute if you are needing assistance and you're not familiar with the actual execution process, and you want to get a further breakdown of the entire billing error dispute process. You have two options. You may join my wait list for my next class, Run That Remedy, by texting the word remedy, that's REMEDY, to 407-305-7089, and you will receive updates when registration will open. So the list will remain stagnant until those text messages start to go out when registration is open. But you again may go ahead, if you like to join into the class, and text the word remedy to 407-305-7089. Alternatively, as you see here, I do have a DIY guide for the Billing Error Bible. In this Billing Error Bible is a 51-page study guide. In the 51-page study guide, we break down the entire billing error dispute process as we would in class, but the only difference is that this is a DIY guide. It walks you through the entire process, but you will not have direct access to me to be able to ask questions as you would in class, where you will be getting that one-on-one time with me in clarification. So once you get the Bible, you will essentially be on your own, and that's going to be the difference between the two. But if you guys enjoyed today's video, don't forget to go ahead and like the video and subscribe to this channel. If I drop any gems for you all, go ahead and hit a like for me. I'm going to see you all in the next video, but be sure if you want to go ahead and join the wait list to text the word remedy. It's here on the screen, REMEDY, to 407-305-7089, and you can get that billing error Bible at www.siditycream.com. Again, you can text the word remedy to 407-305-7089, or download that 51-page study guide at www.siditycream.com, and be sure to be on the lookout for the next video in this series. See y'all later.